Hey everybody, let's talk about what happens to your stuff upon your death. And this is a discussion about probate versus non-probate assets. Really chipper stuff, right? I know. But it's really useful to know if you're thinking about doing your estate planning or if someone you know or love is getting on in age and you need to sort of start thinking about your inheritance, all right? So let's think about it. You work hard and save all your life so that you can leave a little something for your loved ones, right? But do you really understand what happens to your stuff after you die? Do you really grasp like how assets transfer upon your death? So today I'll explain both probate and non-probate assets and why that's important. And I'll give lots of examples that you probably see in your own life. Yeah. And make sure you listen to the end because based on what we talk about, you may think, based on a logical conclusion, that there's this shortcut that you can use in your estate planning. But I'll explain at the end why that's usually actually a really big mistake, so you don't want to do this. All right? Cool. So we're going to start by talking about in-court versus out-of-court assets. That's the first important point. So what I mean by that is in-court means that there's a type of asset that has to go through the probate process, go through the probate court, which is a very specific type of court in the United States that every county or area has, where their job is to make sure that assets transfer properly from somebody who's died to the next generation or so, right? And those duties include, making sure the will is correct, or it's real, it's valid, making sure that all the proper heirs have been notified, figuring out who all the proper heirs are. These are all things that the court does as an impartial government entity so that there's no shenanigans, right, when somebody passes away. If there's a will, it's called the probate process. If there's no will, it's called the intestate process, right? Let's see here. So by default, anything that's in your name alone or only your name when you die will go through the courts, will go through probate. And let me repeat that because that's kind of a linchpin concept. Anything in your name when you die or anything in your name alone when you die will go through the probate courts or will go through probate, right? So now that you know sort of the structure of how all this works, let's talk now about the pros of the probate process, meaning what are the advantages of having assets in your name alone, and therefore they go through the court process. And in general, the pros all tie in or all are related to a legal finality, right? So number one, by going through the court process, there are safeguards in place. A lot of people talk about avoiding probate and this and that, and this is why I'm listing out all the pros, so make sure you understand it's not all evil, it's not all bad. I mean, there are cons, definitely, I'll get into that. But there are some advantages, and there's some reasons why you would want your heirs or your family to go through probate. And one of the reasons, the first reason, is safeguards. And what I mean by that is the court has procedures, parties, and everything is sort of structurally in place to protect people who may not be in the best position to protect themselves. And some obvious candidates for that are minors. If you are survived by your kids who are under the age of 18 and maybe don't have the maturity or savvy yet to defend themselves, I guess, or properly look out for their own interests, the court has a whole system set up to have a guardian ad litem or a temporary guardian appointed on their behalf to make sure they're not getting screwed, essentially. Excuse my language. Similarly, if there's an heir or a beneficiary, if somebody's supposed to inherit, but they're incompetent or special needs or disabled in any way, then yes, similarly, there will be a safeguard and a procedure in place to make sure that their best interests are protected. Similarly, in terms of another reason why probate can be advantageous is that it has processes to make sure final creditor bills and final taxes are paid, right? There's all sorts of rules and steps and procedures that you can follow this structure to make sure that by the time you do close the estate, if you've done things properly, that there will be no more lingering taxes or debts, or at the very least, even if there are, if you follow all the procedures, you should be free and clear from any liability. You don't want to get sued later and have somebody say, I need $10,000 back from your inheritance. I already spent that. That was years ago. You want to make sure there's proper finality. Yeah. So just as one example, as part of the probate process, there's a 7-month statute of limitations. I'll get back to that in a second, against creditors once probate has taken place. So if son gets appointed as the executor on January 1st, yeah, and it's in the court papers, it's in the public record, it's official, then any unknown creditors out there, whether it's American Express, your Home Depot card, Time Warner Cable, or even IRS, they have 7 months from that date. So we said January 1st, yeah? So they have until, I guess, July 1st, yeah? Those creditors have until July 1st to submit their bill, to raise their hand and say, hey, I'm owed money too. Make sure you pay me before you give out the estate to the children or the heirs. And if they don't submit their claim during that deadline, that 7-month deadline period, also again known as statute of limitations, they're poop out of luck. They can't get their money now, right? At least not from you as the executor. And there really isn't any similar structure outside of the probate process. I mean, I guess there might be through case law, but it's just a lot more structured if you go through the court process. And one of the last benefits of going through probate is it's all in a centralized place. So if somebody lived or died in Manhattan, where we are, and you have a distant, your next living heir is a distant relative, in my case, from Korea, they might not know where to look, who my attorney was, where I may have stored my will, do I have a safe deposit? That's really hard to sort of suss out, right? But if they know I'm from Manhattan, bing, bang, boom, go to the Manhattan courthouse, and if there is a will, or if somebody else has filed a will, everyone knows to at least check the local courthouse, right? It's a very centralized location for things. And if it's been years, and maybe somebody thinks I owed the money and I've passed away, then they can check that. They know where to look to see if an estate has been set up. That's not the case if you do other things, like do things with a revocable trust, which is sort of off the books or at least out of the courthouse. So although there are advantages to that, which we'll talk about, it also makes it much harder to locate and to get finality because not everyone knows where to look, and it's not as easy to have everything in one place. Yeah. Okay. So let's move on now to the cons or the drawbacks of probate. Okay? I like this picture. All right. So it's mostly the typical pains of dealing with any court, government entity, or bureaucracy. Those are really all the cons of probate. Number one, it's slow. I'm going to say that again. Probate is slow. It'll take a minimum of 9 months, I would say. And in often cases, it could take years. And if you're wondering why is it so long? We just mentioned that there's a 7-month statute of limitations, or let's call it a waiting period, before you can give out the money because you have to make sure that any unknown creditors have had a chance to raise their hand. So that's just, boom, 7 months right there. But even in terms of just filing the paperwork or getting claims forms signed, or just there's a lot of paperwork that gets pushed around between heirs and the executor and between the executor and the court. And there's just a lot of movement there. And hilariously, everything is still, or for the most part, is still paper documents that have to be originally signed and snail mailed to each other. So, you can't upload. You're probably used to uploading, scanning PDF, all that stuff. That has very limited uses in probates. So you just imagine we're like 10 years in the past for everything that we have to do. So everything's just slow. And, people, if you need an heir to get a notarized document signed and sent back, just think about it from your perspective. When was the last time you went to a notary? You got to figure out where that is, right? And then you find out, okay, that the bodega or the bank near me has it. You go there, you sign it. Now you have to figure out how to scan this thing, mail this thing. Maybe it's been years since you've used a stamp, and maybe you don't even know what a stamp costs anymore. Or, there's just a lot of friction because the whole process is so antiquated. But anyway, each person has to go through that, and getting a document back using current standards could probably take just a few minutes, or even just a couple hours. Now it might take a few weeks. Maybe not weeks, but you know what I mean. Much longer than you would think. And if that's happening with 5, 6, 7, 8 years, you just a lot of friction. Okay, let's talk about costs. Another drawback of probate are the costs. there are going to be court fees. You have to pay the court for to open a case. Yeah, you have to pay an attorney in most cases to assist you with this whole process. And all these things wrapped up together, accounting fees, executors' commissions, all these things added up can be thousands, sometimes even tens of thousands of dollars, excuse me. And it's probably, in many cases it's worth it, right? But it is a cost. And then the last sort of major drawback of probate is that it's very public. So this is the flip side of the coin, where earlier we talked about it's cool, it's good that it's centralized and everyone knows where to go and everyone knows where to go to look. But if you're like a celebrity, or if you're just a very private person, maybe having all your stuff, all your final affairs in the public eye or accessible by public record, maybe you don't want that. Just by way of example, if you're in New Jersey, I forget which county, you can pull up James Gandolfini's will, because his estate went through probate very publicly. So if you ever wanted to see his signature or his will, it's all right there. Prince, I think he was in Minnesota. His will is also public. Frank Sinatra here in Manhattan, also. So if that's something that bothers you, maybe that's worth considering doing a non-probate method of planning your estate. Okay. All right. Next, why don't we move on to some examples of non-probate assets. So we've just covered that probate means you have to go through court, and we've talked about the pros and cons of court. Now we're going to talk about the other side, the other option, non-probate assets. So how do you avoid that if that's what you desire? The easiest examples are anything with a named beneficiary or a named co-owner or joint owner. And I'll give you just a list of examples. Life insurance. You usually name somebody as the beneficiary of your life insurance, whether it's your spouse, your kid, or something like that. So when you pass away, your spouse, let's use that as an example, needs your original death certificate and a claim form, and maybe the policy number, maybe not, goes to New York Life or Northwestern Mutual, either calls the 800 number or finds an agent, submits that paperwork, bing, bang, boom, no court, they get a check for the death benefit of the life insurance. And in many cases, you want that, at least the life insurance set up that way at the very least, so there's some liquidity. So there's some cash to work with when you're doing the rest of the probate. Other examples of non-probate assets: IRAs, retirement accounts, 401ks, all those things. Very similarly, you can name beneficiaries. And actually, specifically for IRAs and 401ks, there are many tax benefits to naming certain people, like your spouse or kids, as beneficiaries. So talk to your tax advisor regarding those accounts. Right? Real estate, whether it's a house deed, a condo deed, or here in New York, co-op share, proprietary lease and share certificates, If you are named as joint owners, or in New York as husband and wife, you don't even have to say joint owners. You can just say Anthony and wife, husband and wife. Then the second, when one of the two people dies, the second person automatically owns the whole thing, right? So husband and wife own a condo in Manhattan. Husband dies. What does wife have to do? Nothing. She immediately, upon death, owns 100% of the condo. Okay. Yes, you need to push some paperwork to maybe update the deed to reflect the fact that husband's passed away, but you actually technically don't even have to do that. You should do it so that you don't create a whole mess of paperwork that needs to be done when wife passes away later, but it's not super urgent. Bank accounts, even bank accounts can be done this way, can be made non-probate. Maybe you've heard of this. You can make a bank account a joint bank account. You can make a bank account. Let me give you I'm going to rattle off the list of examples. ITF stands for in trust for. TOD stands for transfer on death. POD stands for pay on death. Totten trust, it's just it's a type of account that pays out to somebody upon your death. Did I say ITF? Anyway, there are small nuances that make these slightly different one from another. I don't want to get into that now. The point is there are many, many options to hold bank accounts and brokerage accounts that don't have to go through probate if you name them this way. And then lastly, a common example that you hear about maybe through internet searches or whatnot is trusts, often called revocable trusts, living trusts, or grantor trusts. And what these are the simplest kind of trusts there are. And what they're basically a wrapper. Okay, let me say that again. They're like a wrapper that you put around your assets so that they're no longer owned by you, or they're no longer technically owned by you while you live. And rather, they're owned by this trust that has its own instructions about what happens when you pass away, and that's how trusts are used to avoid the probate courts. All right. Okay. Now it's also important for you to know. Let's see here, that you can change your assets from probate to non-probate pretty much any time. And what I mean by that is, okay, let's say I bought a house before I got married, and it's in my name alone, and then I got married. Okay. If I want to add my wife to it, just got to hire a lawyer or just figure out on my own how to update the deed. There's nothing really stopping me from doing that. I have a bank account, a savings account, online savings account that has some money in there. I got married recently. I'm going to keep using that example because it's the easiest example. All I have to do is go online and update the beneficiary designations. Usually they can do it online. Maybe you have to download a PDF, sign it, and send it back. But changing or updating beneficiaries or ITF, that kind of thing, pretty easy to do. Okay. All right. So we've talked about the difference between probate and non-probate. I've given you a couple of examples. Now, this is an important caveat. You must understand. This is super important. Non-probate assets override wills, and I'm gonna pause while I think an ambulance is going by because this is an important point. Yeah, this is New York's finest, right? Come on, get out there, save a life. All right. So non-probate assets override wills. What does that mean? I'll give you an example. Let's say my wife and I have our first child. We're in love. We're swooning over this creation we've made. And I immediately decide to be the responsible adult and go to all our assets, bank and brokerage accounts. And I've named my wife as the primary beneficiary, for example, and as the successor, the backup in case my wife and I die simultaneously or something like that. Our first child, I name her, beautiful daughter, as our secondary beneficiary. But I continue to live. And have more kids. And guess what? Just like many, many, many people we've seen in our practice, I forgot about all those beneficiary things I did. And I continue living my life. And then one day I say, I have a big family now. I'm a big family man. I need to write my will. So I go to see a lawyer, pay a lot of money, and get a will that says everything to my wife. But if my wife is not alive or we die simultaneously, then everything equally to my kids. That's fair. Is that what happens if I die? What do you think happens? You're right. So the will only controls anything that comes through probate, any assets that go through my estate. So if I've named, remember, right after the birth of my first child, I ran around and I named my first child as the beneficiary on all my assets. There's nothing that's going to go through my estate. And my second kid gets bupkis. Now, is that what I wanted to happen? Obviously not, because I went out to make a will and include, say everything gets divided equally. But because this just happens all the time, you might think, this is ridiculous. Who would forget? Everyone forgets. Okay, not everyone, but so many people forget. This happens all the time. So many unintended consequences. And let me explain the reason for that. Well, let me move on to the next point, and it touches on that. So this example I just gave you is the perfect illustration of why simply converting everything to non-probate is not the same thing as estate planning. So this is the logical trick I was telling you about. You might think, oh, cool, Anthony just taught us that if we name beneficiaries on everything, we don't have to go through probate. We don't even need to make a will. We just save so much money just in one step. I am not telling you to do that. I am not telling you to do that. So if anyone ever points to this video, this is, whatever time marker this is, Anthony said, don't do that. And here's why. I mean, I know it sounds logical. It sounds like, oh, cool. I mean, all the dots connect. That makes sense, right? Wrong. And the example I just gave now is why it doesn't work. Because people forget, right? Why do people forget? It's not because we're careless. Or I'm a smart planner. I'm not going to be like those careless guys that forget. Everyone forgets because it is not conspicuously listed anywhere. Do you think your statement says at the beginning, every month you get a statement or a PDF, I guess these days? It doesn't say, Anthony Park, Vanguard, brokerage account number ending in 123. Oh yeah, and then under that it says beneficiary spouse, backup beneficiary child. There are no reminders, right? Nobody reminds you to update. So unless you're one of the very rare few people who will conscientiously take care of this, at the very least, there's going to be some skew in how you in your beneficiary designations that doesn't match what you intended. And I just can't say enough. We've seen this so many times. It's frustrating. Right? I'll give you an example. Okay. Yeah, I'm going to try to anonymize. I almost used a real name. So let's say Kurt was in love with, I think her name was Jasmine, and they weren't married. They were lovers, right? Oh, they really cared about each other. They didn't have much, but they had each other. Is that a song? I don't know, maybe. So Kurt had a little bit of money. I think he had a couple $1,000, and he added Jasmine as a show of affection, as a show of his commitment. He added her as I think it was a joint, or as a beneficiary to his savings account. Hey, baby, we're in it. You know, I may not have put a ring on your finger, but we're in this together. Look, I put you on my savings account. Okay, that's interesting. Why don't there's other signs of commitment, but okay, you did that, Kurt. Nice. But I think you know where this is going. Didn't last, unfortunately. Kurt and Jasmine went their separate ways, and decades later, Kurt remarried. Or not even remarried, got married for the first time, had a beautiful daughter. Daughter grew up to be a wonderful young woman. Kurt lived a very fulfilling life. All the while, by the way, he's maintained his account with this bank account. And, you know, unfortunately, at some point, nature catches up to him. I mean, I'm dragging this out, but you get it, right? Daughter mourning her father, her beloved father, goes about her business of trying to collect his accounts, only to find out, who's Jasmine? Why is she getting all this money? Like, it's the most jarring thing, and we've seen it more than once. We've seen it several times. It's just jarring. It's terrible, and it's just not estate planning. Naming beneficiaries on all your accounts is not estate planning. It's gonna bite you. So that's what I have for you today on what happens to your stuff upon your death. Hopefully I've given you a couple of examples that you can sort of use in your life and help you figure out how you want to approach things. Or if you're on the flip side, if you're helping wrap things up for a family member or a loved one, hopefully I've helped you in that area. Oh, check out my book on Amazon, How Probate Works, covers this and a lot of other topics. And talk to you next time. Take care.